Time for the Law School Teaching Hour here on Legal AF. In the last 48 hours, we've had 3 different administrative stays by appellate courts from the Fourth Circuit to the DC Circuit to the Supreme Court. I thought this was a great opportunity, kind of like a TED Talk meets a law school meets Legal AF, to explain what happened, why it happened, what is an administrative stay, and what does it mean in the individual cases. These all arise out of some failed unconstitutional immigration policy of Donald Trump, either his use of the Alien Enemies Act or his refusal, having wrongfully deported Abrego Garcia to El Salvador, to return him. And 3 different courts, including the highest court of the land, have issued in the last 48 hours administrative stays, including the United States Supreme Court, like at 10 o'clock at night on on Friday night. Well, we're back. Let's use it as a teachable moment. We're here as a fellowship, as a community. We're on Legal AF together, and I could use you to hit the subscribe button, right? Plus, you'll get reminders automatically with videos just like this and tutorials. All right, Professor Popok, here we go. Administrative stay is the lowest form of stay an appellate court can issue. It is not determinative of the substance or the outcome of the ultimate appeal, but because of its timing, it may actually be the final result and does, like a stock market, especially under Donald Trump, it does provide a roller coaster of emotions as an administrative stay gets entered or not entered, bad things happen or don't happen over the course of a lifespan of a case. Now, normally, except in emergency applications on appeal, appeals can take a year and a half from beginning to end. Not when it comes to Donald Trump's unconstitutional attempts to attack the rule of law. They go much faster, usually on a version of an emergency application. An emergency application is on bare bones briefing. No real record developed of facts below by the trial court judge. I'm going to stay in federal court for this entire teachable moment. So this federal court district judge, trial level judge develops the facts, then goes up to an appellate court, always a 3-judge panel, randomly selected. It may not seem random at times, but it is. Then, failing there, you lob in a request or an application or a writ of certiorari up to the United States Supreme Court, which is how you get your appeal. If the Supreme Court's interested, they will tell you. If they're not interested, they will tell you. If they're interested in the appeal, but not on an emergency basis, they'll tell you that as well. Administrative stay is a hold the ring. It's a pin in it, temporarily, usually for hours or days or maybe a week at best, to allow full briefing in the case. It's not supposed to be construed as a substantive decision of the court. Oftentimes they cite to the law that says this is not a decision on the merits of the case. It does give the court time for full briefing. Depending upon what's on the other side of the case, that could mean people are being deported during this administrative stay, money's not getting spent, funding's being cut off, or the like. Depends on what's going on in the case below as to the impact of that administrative stay. We've got 3 I'm going to use as an example in the last 48 hours. Started with the Fourth Circuit Court of Appeals 3-judge panel led by Judge Harvey Wilkinson, one of the lions of the Federalist Society. He's a rock rib Reagan Republican, but he wrote a scathing decision and he refused to enter an administrative stay of any type against Judge Zinnes's order about Armando Abrego Garcia as she tries to get down to whether the Trump administration is in contempt, having set up a discovery process for her to determine whether they're in contempt for having failed to do anything to facilitate the return of Armando Abrego Garcia, despite Supreme Court Order 9-0 to do just that. So the Trump administration ran to the Fourth Circuit to ask for a stay of her order at the trial court level about the process leading to contempt, about their treatment of Armando Abrego Garcia. Now, that request for a stay denied. So we got the Fourth Circuit Court of Appeals 3-judge panel denied on a stay, meaning Judge Zinnes continues to, with deadlines set over the next week, to complete the discovery in the process to determine if the Trump administration could be found in contempt. It's not helping the Trump administration's cause that they taunted Judge Wilkinson and the Supreme Court and us and the rule of law by saying, look at our new funny headline. We drew faces and mustaches and noses and penises, I guess, on the New York Times headline about Armando Abrego Garcia. And by the way, Senator Van Hollen, he's never coming back. Ha ha ha. Okay. That came out of the White House official social media account, I'm sure directed by Stephen Miller. Now, that's the fourth. And they wrote a 7-page scathing rebuke of Donald Trump with soaring rhetoric. It's the reason I went to law school. I did a separate hot take on Judge Wilkinson and what he wrote, imploring the executive branch to appeal to their better angels and rule for the rule of law. But there are no better angels in the Trump administration. It's only another cast of devils replacing other devils. So that didn't work. And we got the social media posting in response. Now let's move from the fourth to the Supreme Court of the to the District of Columbia Court of Appeals first. Sorry, chronological order. There, the Trump administration appealed last week to a 3-judge panel about Judge Boasberg's decision about the Alien Enemies Act, and more particularly about his injunction that was in place a month ago that required that 2 planes be grounded and not end up in El Salvador filled with people. And yet they went anyway. So the judge made a ruling, a finding of probable cause that the Trump administration committed a criminal contemptuous act, contumacious act, and he's about to refer it to a prosecutor. Trump administration runs to the D.C. Court of Appeals, and it's a bad pull, as they say. Bad 3 judges. 2 of the 3 are Trumpers. I said it before. Judge Rayo, who clerked for Clarence Thomas, and who is a Federalist Society believer, and Judge Katsas, who's worse. The only one that I liked on there was Pillard, an Obama appointee, and I said it's going to be push-pull in the appeal to try to get Rayo over with Pillard. So they didn't even wait for an emergency application to be filed by the Trump administration asking for a stay. They just issued 2 to 1. They issued the stay administratively, Rayo and Katsas, staying Boasberg's process on the way to criminal contempt and the referral to the prosecutors and the deadline of Wednesday that he set to find out who violated his order. He wants names from the Trump administration, or he wants them to return the planes. That's all off. Instead, they set a briefing schedule for Wednesday for the plaintiffs to respond, and then they'll get the 2 sets of briefs and they'll make their ruling at some point. But they have put a pin in it and a stay in the case of the trial level process for now. Judge Pillard dissented in a footnote and said, I would not have granted the stay, administrative stay, even though it's not on the merits. It effectively is giving them relief they're not entitled to, that we don't have jurisdiction over this process as of yet. Why are we doing this? So they put a stay in the case subject to the appellate briefs coming in. So one day they'll rule on the merits of criminal contempt, but not today. But in the meantime, they don't want his process to continue. A bad use of the administrative stay power of a district court. Let's talk about a good use of the administrative stay power to round out this hot take. That would be the United States Supreme Court, who apparently in a 7-2 decision, with only Alito and Thomas dissenting, ruled at about 10 o'clock Eastern time last night to stay and to order that an entire class of Venezuelans who were about imminently to be deported to that killer jail in El Salvador in the Northern District of Texas, those planes are grounded. The Supreme Court justice said, until we say otherwise, you are commanded not to let them leave the country. They're concerned that the Trump administration is not taking seriously their decision that all of these people are entitled to real effective due process and real notice. They got no notice. It was in English, not Spanish. They were given no time before they were about to be loaded into planes. And the lawyers for these people in Northern District of Texas, in Blue Bonnet, Texas, apparently, they were running from court to court to try to get relief. They tried to get Judge Boasberg to do it, and Boasberg said, "My hands are tied." The Supreme Court said, "I don't have jurisdiction. It's where the habeas corpus petitions are filed, in this case in Texas." The Southern District of Texas judge said, "Sure, we'll block Southern District people, but I'm not going to do a global or universal injunction." That's the problem. When judges try to restrain it to their little group of people and other people are being harmed. They then ran with an emergency petition to the Fifth Circuit Court of Appeals, and they denied it because they're right-wing leaning. Those planes were loaded They filed an emergency application that got granted in a day at least an administrative stay level. Again, not on the merits, but 7 people on the Supreme Court think maybe we shouldn't let these people go to El Salvador while we're trying to sort out due process and notice and constitutional rights. How about that? So at least they finally woke up. So there you got it, everybody. 3 different attempts at an administrative stay. You found one bad one good one, and one denial that ended up being, turning the screws on Donald Trump. We cover it all just like this with breakdowns on Legal AF, the YouTube channel. You're here already. Boom, hit that subscribe button. Then you'll never miss a video because you'll get reminders. And so I really appreciate you. So until my next reporting, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.